if you don't agree with the dentist's recommendations, then somebody's going to have to file a motion. I'd hate to have to do that over baby teeth x-rays. You guys, if you have a strong opinion, I'm not prejudging that issue. Good morning. This is the time set for case D. Can we have counsel make your appearance, please?
Good morning, Your Honor. Richard Schonfeld appearing for the plaintiff. She is also present.
The defendant and proper person.
All right. So I have read almost everything, although you guys have a lot of exhibits. I haven't read every word of some of those exhibits, but what I can find is that the parties have one child together who will be 7 later this month. The court has exclusive continuing jurisdiction over all matters related to his custody, care, and support, as both parties and the minor child continue to reside in Nevada. There's a lot of issues. Some of them may seem small, but there's a lot of issues and complaints back and forth. But defendant has made a prima facie case for contempt, so he gets an evidentiary hearing. Plaintiff has also made a prima facie case for contempt. So I'm going to grant the parties an evidentiary hearing, although cost-benefit analysis is not my job to do. It's your guys' job to do the cost-benefit to see if it is worthwhile, because whoever prevails in that is probably going to get a reward of attorney's fees and costs. So it's a matter of there. But I am also going to limit you. I'm only going to consider events that occurred after October 13th, 2021. So if it occurred before that date, we're not going to address that. That was the date of the last substantive hearing where I clarified some orders, so that'll be the relevant time period. I think that half a day will be enough, but I'm open to listening to if you think you need more. A lot of it's going to be me reading the Our Family Wizard and interpreting those. So because if I give you a half day, that means each side, and you'll go first because you filed your motion first, we'll get 90 minutes, and that's it. And I will keep you to that if that's what we set it for. So if you think you're going to need more than that, I want to know now, and we'll set it for more than that.
At first blush, my guess is it might take a full day just because of some of the issues with witness impeachment and possible false statements, but it's possible that we can make a half day work.
Well, in a way, this isn't like the custody trial, and there's not he said, she said. It's either in writing, in a text message, or in an Our Family Wizard. I mean, that's basically the complaints both of you have is what's been communicated in writing. So that's fine. Mr. Schonfeld, what is your thought about the length of the evidentiary hearing?
Your Honor, as the court's aware, this is an expense to my client, even though the court has stated the potential for an award of fees. So my request would be a half a day so we can try to keep the expenses down.
And part of it is going to be an issue of time management as far as you both should stipulate to the admission of the Our Family Wizards. Those definitely can't be manipulated. They're on somebody else's server. The text messages you guys may have objections to, and that's fine, but streamline it, because the problem you're going to have, besides the amount of time and money it costs to do that, is availability. I'm looking at what is opened up. Here we go. I mean, I could give you guys a full day on September 30th, but that's no time to do any discovery or preparation. If Mr. wanted to get an attorney, that might not be enough time to do that. But a half day, I could give you one on December 22nd.
My guess is that would interfere with one or both Christmas vacations. That's the only issue on December 22nd. And you're correct. I would like to proceed with counsel at an evidentiary hearing. That's my plan.
Okay. December 22nd is Thursday. And I do think, let me pull my calendar. I think that is in the middle. When do they get out? For Christmas break, they get out on the 15th. So that would be right in the middle of there. So the next available half day I have is February 14th for half day. If I give you guys a full day, probably going to be April 14th. Or I could give you before that maybe 2 half days back to back, like on a Monday and Tuesday.
Your Honor, we would prefer a full day. If it's going to be a full day, then it should be 1 day or just a half day.
Yeah, it does. It seems to cost more money when you split it up. As attorneys, you give them more time, they'll do more work. I don't mean that meanly. That's just what attorneys do. That's what I would do. Like I said, I can do a half day on February 14th. Or we'll have it until wait till April, and then issues don't get resolved. I don't like waiting till February 14th on this, but I understand definitely whoever has that portion of Christmas break is going to want to have to do this for that time period. So,
I do believe it's plaintiff's time, so it's.
well, and yes, I mean, I don't know off the top of my head whose time it is, is what I'm saying. Whoever it is, nobody's going to want to do a trial during the Christmas break time with him. And understand if it was yours, you might want to be in Ohio with your family. That's okay. So why don't we set it for the 14th and do the half day? And I'll expect if you get counsel, they can reach out to them, or I'm going to expect you guys to stipulate to as much of the exhibits as you can. Definitely, they are family wizards you want to use. So let's set it for the 14th. That means there will be a calendar call on February 9th at 9 a.m. And then both of you, I don't believe, I know you submitted an ex parte request for an order to show cause, but I don't think the order to show cause was actually submitted to me for signature, was it?
I am not certain if I submitted an actual proposal.
Because I don't remember actually signing one in this case. After you filed your motion, no, I don't see one. So both sides can submit. And the problem with the order to show cause has to be very as detailed as your affidavits. So do the order to show cause, sir, and I'll sign one for both sides for that date. And then that'll be in person. The calendar call on the 9th can be by video if you want to, or come in person, whichever you want. I'm here either way, but you can do that one by video. But trial on the 14th will be in person. That's a Tuesday afternoon. And since both parties are requesting an award of fees, I'm going to need, by February 8th, both parties are going to file updated financial disclosure forms with proof of their income attached and fill out the asset and debt. It's not normally required in a custody case, but in this case, I want to see assets and debts as well as proof of income. And so file that by February 8th.
Does the court have a date other than the week of February 13th in close proximity? I'm scheduled for a 1-week family court trial in California that week.
Let me see where else we're getting. What other half?
The 21st.
We have a 21st.
That'd be perfect.
Yeah, because what is he in second grade now or first grade?
Second grade.
Second grade, right? Okay. Yeah, and probably on the 14th have some party or something that one or both parties may want to attend. So we can move that to the 21st. That's the day after President's Day. So that's a Tuesday afternoon. And then the calendar call would be at 9:30 on the 16th. So then on February 15th will be your deadline to file your financial disclosure forms.
So the calendar call postdates the evidentiary hearing?
No, we're moving the evidentiary hearing to the 21st because.
Oh, okay, sorry, I didn't.
Mr. Schonfeld has a potential conflict. So it's either to schedule it now on the 21st. That means that the calendar call will be on the 16th at 9:30. And if you guys want to provide any pre-trial memorandums, we'll put the due date for those also on February 15th. Any questions?
Not about that, Your Honor.
All right, and all the current orders remain in full effect. And if there's any clarifications to be made to anything, then we'll do it at that time too, once I hear the evidence.
All right, I do have one request that's not part of the motion. In the court's order regarding out-of-state vacations with a minor child, it says the party is to give timely notice, but there's no definition of what timely is. The court's inclined today, our request would be that, for example, if my client has custodial time and on Thursday night she decides that she's going to take the child to Zion over the weekend, that as soon as she knows of out-of-state travel, she give notice, and that would be deemed timely.
Okay.
I do think the parenting coordinator's decision does require a 14-day notice for out-of-state travel.
Okay, but your Honor's order is subsequent to that, and it just says timely notice.
Right. I mean, if it's the twofold issues. One is I'm taking my custodial time and doing this with them, going to Disneyland, whatever. That doesn't require as much notice as I'm taking your time for my vacation time, which you guys actually don't have that right under your existing orders. So, as long as you know on the day of travel, that's reasonable. So you may want to be taken to Disneyland, and it may come up suddenly. You want to take Disneyland. You have that right. It's your weekend. You have a 5-day block. That's your time. So.
I mean,
14 days doesn't allow either one of you to make more of a last-minute decision with your own time.
Right.
I mean,
So
that is fine with me.
as long as it's in writing on there with the information. So you going to Zion, where are you going to stay, that kind of stuff. You're going to Disneyland, which resort you're going to stay at or which hotel, something like that. Both of you have a right to know where your son is.
So the same details about the travel that was in the parenting coordinator's decision.
Right, yes. I mean, obviously, if you're going up to, I'm trying to think, Duck Creek and going camping, you're not going to really have a place there, but you're going to say, we're camping here, cell phone may not work, so I'll have them call you at the time or something like that. I don't know if either of you might want to go camping where there's no cell phones. If you do, then you have the right to do that. So whatever, I mean, you guys both seem to like to do a lot of enriching things for your son. So I want to have both of you have as much freedom as there, but also both of you have the right to know where he is.
Thank you, Your Honor.
I think that's fair, yes.
Okay, so if you want to put that in an order for clarification, you can do that.
Okay.
And then both of you submit the orders to show cause, and I'll review and sign those.
So on the order for clarification, it would be 1 day notice in terms of in-state travel during your own, out-of-state travel during your own custodial time?
Yeah, let's say we want to say 24 hours notice.
Okay.
So that at least you got to make up your mind by Wednesday if you're going to go on a Thursday or whatever.
Perfect. Thank you.
And then, yeah, and then they have our family wizard, so that keeps it all documented nicely. All right. Thank you all.
Thank you, Your Honor.
I apologize. I have
No,
one
you're
more clarification. The issue with the dental x-rays may be time sensitive before the order to show cause comes up.
Okay. I didn't see something in your motion on that. Is it, what is the issue? Tell me what the issue is.
Plaintiff has stated that her position is that she's unilaterally opposed to x-rays. And at the previous visit, we were able to agree that our child would get x-rays at that point. The x-rays showed some areas of decay and possible need for fillings. But the dentist kind of deemed them watch spots. But I would request a clarification that if the dentist deems that x-rays are required more frequently for these watch spots or areas of decay, that we would be able to do that.
Okay, so the parties have a disagreement about x-rays?
I said I'd like to decide on x-rays on a case-by-case basis because I just didn't want them x-rayed all the time. And last time we were there, the dentist said, we recommend it. And I said, okay, I don't know if this needs to be litigated.
Okay. And you guys I know you have agreed on the eye doctor he regularly sees, Dr. Quinton, right?
Yes.
Do you guys have a dentist you guys have agreed on in there?
The last dentist we saw, we agreed on, but he doesn't take our insurance. So in my mind, I'd like to try to find another pediatric dentist. He's not due for a checkup yet.
Okay. So, I mean, you agree with her on let's get him covered, go to a dentist that's covered by at least one of your insurances, right?
If possible, yes.
So the dentist, there was a third person listed in the PC coordinators. I assumed that was the dentist. Maybe that wasn't the dentist.
May have been an ophthalmologist, ophthalmologist.
Yeah, there's an optometrist. So you guys need to agree on who is his normal dentist.
Mhm.
So, and it should be somebody covered by at least one. If both insurances, even better, less out of pocket for both of you.
Right.
So then I guess my clarification would be to follow the recommendations of the dentist.
Okay.
If you don't agree with the dentist's recommendations, then somebody's going to have to file a motion to do that. And I'd hate to have to do that over baby teeth x-rays. But you guys, if you have a strong opinion, I'm not prejudging that issue. If one of you or both of you have a strong issue one way or the other and want to minimize his x-rays, I get that. So I know normally I think they recommend at least once a year even if they do the every 6 months for the checkup, but like once a year for the x-rays, I believe.
That's correct.
That's what I believe they're doing.
The other clarification, and this may be too much for today, but my father is a dentist and is able to stay on top of like these areas of decay and fillings and stuff more consistently, but it's just been a little unclear of what he's not able to actually physically treat the child according to the orders, but I'm not sure if he's able to look at the records, look at the x-rays, even look inside his mouth. It seems like an awful waste to prohibit the free dentistry of someone that we can trust, but that has been plaintiff's position.
Or we've litigated this issue at least once, maybe twice already.
Again, it's not a matter of whether grandpa is qualified or not qualified or anything. It's a matter of inclusion of both parents in that treatment plan. But as I read the order, I don't think there is a limitation on you consulting and getting you have a right to the records. If you want to get, or I don't know if you can send them now electronically. I think you can. I think they're doing digital x-rays now, going from memory for my own dentist, that they're digital. You might even be able to email them to him. And you can consult with anybody. You can't take your son to him.
Okay, so consultation.
If you want a second opinion from your dad, say, hey, look at these
records and x-rays.
Look at these x-rays. This is what the dentist here is saying. You're entitled to get that second consultation, but not take your son there.
Okay.
It's a matter of mom not feeling included with him as a treater. That's all. It's not saying he's not qualified or something. And if you two agreed and you could do free work for you guys, then that's something you should discuss at that time. But the regular dental care, such as checkups, even for the fluoride treatment that some people choose to do, stuff like that, most of that's going to be covered by your insurance. Mm-hmm. And you guys want to do that routinely here where you live. So, but I don't see that there's the problem with you consulting and getting your second opinion, as long as he doesn't need to examine your son, though.
Okay, so consultation, second opinion, record examination is okay.
Yeah.
Actual.
And mom has the right to do that if she wants to get a second opinion too. For if you don't agree with the dentist's recommendation that he be x-rayed on this particular incident, then you have a right to get a second opinion before that's done.
Okay.
Just so we're clear on that, it's not no physical examination.
Right, it's not a physical examination.
When we say he can consult with his father, he's consulting with his father by himself, not with his father the records and get his father's opinion.
Yes.
But that ends there.
Yes.
Okay, so the key is no interaction between grandpa and
no physical consultation on his teeth, because mom can't be involved in that. That's where mom's concern is. But you have a right to get both second opinions. So if you guys don't have an agreement right this minute on who his normal treating dentist, then so you guys need to look at that and find out who's covered and see if there's an overlap too, and somebody convenient to you guys.
Needs a new dental provider that takes our insurance. He also needs a dermatologist visit, which we've agreed on. We don't have a provider. I'm wondering if we can split that work. We have trouble communicating. If he could pick the dentist, if I could pick the dermatologist, or vice versa, so that we don't have to have that communication between us.
You have his insurance, both of the insurance informations now, right?
Yes.
I know there was some discussion of that in the motion and the opposition. You want to split that up, sir? You pick one and you pick the other? I mean, usually your pediatrician's going to say, hey, you need the referral to a dermatologist.
They have, they have a list of recommended dentists.
So you
but
got to
there's
pick one from the
multiple.
list. Yeah, and who can you? And with those kind of specialists, it's a matter of who you can get into, because some of them are booked way out for some of these specialties. It's weird here. Like getting your car fixed. You can't get it fixed quickly enough. They can't get you in. Same thing with medical providers. Sometimes you can't get in. So if you want, so what she's saying is, let's not confer, sir, you pick off the list the pediatrician provide for the dermatologist, she pick a dentist. Hopefully she can find one that's covered by both insurances and maximize you guys' or minimize out of pockets.
And I just want to clarify, if I can't find one that takes our insurance, I'm not breaking any rules. It just happens that no one takes our insurance. And that would be fine.
Well, there's definitely some on, you're at HPN?
Yes.
You're with HPN, so there's definitely somebody on HPN that should be covered.
I had difficulty finding a therapist. That's why I'm just bringing
Well,
this up.
the whole therapist issue is a whole other can of worms here on it. So, I mean, but the order still stands. I guess if you still feel he needs a therapist, it's a matter of, I don't know that the two of you are ever going to agree on a provider for that or agree on the need. I think Mr. said he didn't think there was a need.
I certainly think there's a need. I think
Now you agree with the need, okay?
Yeah, I think the issue was, well, the first issue was that it wasn't covered by the insurance. And then my opinion is that it was used to create more issues. But I do think he needs a therapist, but for the time being, it may be best to just wait for the hearing and decide at that point.
Well, it's the hard part you guys have is that there are so few mental health providers, period, let alone qualified mental health, let alone that treat children as young as him and do the appropriate, I don't know, play therapy that they want to do or art therapy or those kind of modalities. It's hard. We don't have a good stable of mental health providers, period, for adults, children, anybody. It's really hard. So it's going to be hard to find somebody. And then a lot of insurances, I think HPN is contracted with one of those clinic-y kind of places, and I can't remember off the top of my head who I'm thinking of, but
Okay.
yeah, that you have no choice but to go to a certain place. That's where your insurance limits you on those kind of things. And sometimes they limit how many visits a year that they will cover if you go into covered. I'm thinking of like HBI, that's who I was thinking of, the Health Human Behavioral Institute, or there's a couple of providers like that where they have, you just have to take who they have, that kind of thing. And that's where the therapist is much more complicated than getting a dentist or a dermatologist or an eye doctor. All right, so you guys have to keep trying the best you can to get these things done, but we do have an agreement that Mr. is going to pick off the list of the I can't even say the word right now.
It's okay.
Thank me, help me.
Dermatologist.
Thank you. And that mom's going to pick the dentist, hopefully finding one that at least one of the insurances is covered by. And something convenient to both of you. I mean, I know where Dr. Quinton's office is. I know where, and so it's basically east for both of you to go to Dr. Quinton's office. It's east of
Basically central. It's central to both of us.
Is it? Oh, did you move?
I live on I think it's a little bit north and west for plaintiff, and
Of
it's a
where she
little bit
lives.
southeast for me.
Yeah.
So it's not a bad location.
It's not terrible. So there, I mean, you don't want somebody up Aliante for you
Right.
guys because you don't live up there. That'd be inconvenient for either parent to visit. So, all right, thank you all.
Thank you, Your Honor. I'll prepare the orders clarifying all those issues.
Clarify those things. Yes.
I did want to ask you if it's, because I'm unrepresented, is it going to be criminal contempt or civil contempt? And why? Because I didn't see that in.
Well, and that's a good question. You're both asking for sanctions and for past acts. So I would assume it's a criminal act. And I don't have anything in front of me because we don't have a new financial disclosure form, whether you're able to afford counsel or whether I need to appoint one for you on that term. So are you asking the court to appoint one for you?
I'm not asking the court to appoint one at this point. It's possible, but I would want to know if it was. It seems like it's criminal contempt.
It's criminal contempt because you're both asking for punishment for past behavior. You're not asking for an order that's to compel somebody to do something.
Correct.
So I would say it's criminal contempt. So you definitely have a right to counsel, and you have a right to request an appointed counsel if you can afford one, and then I would have to look at that.
Okay. That's
So
my
if you
opinion.
want one appointed, the sooner you file a motion and file your financial disclosure form with that, the better.
Okay, I'll
And
take
then
that
we'll
under
consider.
consideration.
But if you're
as
going to
fast
get
as
your
I
own,
can.
that's fine too. Of course, you're always
Sure.
have the right to get your own attorney.
And just
But we've clarified a few things that Mr. Schonfeld's going to put in there, such as the dermatologist, the dentist, the travel out of state with 24 hours.
okay, and just for the record, the vexatious litigant motion was denied because
That should be part of the hearing, Your Honor.
Honestly, I don't think that there's frequent enough yet. This vexatious litigant's really hard. I'm not inclined to grant that at this time. But that it's going to be denied without prejudice, so that it is something that if the repeated filings of lacking in merit would get you there, but I don't think we're at that point in time with either party. Yes, coming back with small but important to both parties. They're small when I say it's this kind of allegation versus one of withholding a child, which would be a bigger allegation. These are small, everyday issues that keep going on and on between the two of you, which is why the prior judge said, I believe either you guys stipulated or the prior judge appointed the PC coordinator. I didn't appoint the PC coordinator. It's a balancing act. It's very expensive, as you guys found out, and sometimes doesn't solve anything. So, but I reserve the right to say in February, maybe after I hear all the evidence, that you guys need another one. So, but it's again expensive and another time commitment to go into somebody else and resolve that. But it may be better than coming to court when the court can't get you in as quickly to resolve quick issues. So it's a balancing act. So I'm willing to consider that on the 14th or 21st of February.
and the converse of that, if I were to bring a Rule 11 motion before that time, if the subject matter is so similar that it may be well heard at that point as well.
Something has to be filed before the court can give an
That's
advisory
fair.
opinion.
That's
on
fair.
that.
Yeah, I
That's
mean,
fair.
that is not before me, but
Okay.
obviously you need to comply with the prerequisites under Rule 11.
The safe harbor.
Yes.
I understand.
All right, thank you all.
Thank you.
Your Honor.
See you in February.